Thanks everybody at home. Thanks for everybody here tonight. My name is Ben Heckman. I'm the library director, and I think that it's an appropriate place for the library to have conversations about censorship and so forth. And so I'm excited to present this tonight. I want to introduce our two colleagues and folks who will be speaking with us tonight. Professor Dan Kobil joined Capital Law School in 1987. He currently teaches constitutional law, criminal procedure, and comparative constitutional law. Since entering teaching, Professor Kobil has researched and published extensively on the subject of executive clemency, especially as it relates to the death penalty. He also writes on First Amendment law. His work has been cited by courts, including the United States Supreme Court and legal journals. He's a frequent contributor to newspaper, television, and radio reports on constitutional issues. And today, he's at your library. Michelle Francis is the executive director of the Ohio Library Council, the professional association that represents Ohio's 251 public library systems, including their administrators and staff, trustees, and friend groups. Prior to that, she served as OLC's Director of Government and Legal Services, where she monitored state and federal legislation affecting public libraries, directed OLC's lobbying efforts, and assisted members with legal questions. The OLC is acknowledged as one of the leading statewide library associations in the country, and is consistently recognized among professional associations in Ohio for its outstanding advocacy efforts, information resources, and member services. She's an incredible partner to our library, and we are thankful that she is only a phone call away, and she even answers when she knows it's me. So with that, I want to introduce Professor Kobil, and we're going to present a little, and then we'll go up on stage, and we're going to take some questions that we have prepared and from the audience.
So we're going to talk tonight about an area of the law that often doesn't get taught in basic constitutional law courses, just because there's not a lot of Supreme Court case law on it. But we're going to begin by talking about the library, which I think Justice Brennan summed up nicely with his quote from the Pico case, talking about a school library like a public library being a place dedicated to quiet, to knowledge, and to beauty. Unfortunately, today, libraries are battlegrounds. As we know, if we take a look at the news, there are a large number of controversial cases involving the removal of books from libraries happening. I did a quick look when I was preparing for this presentation, came across the Hood County Library in Texas, which was involved in a national controversy with regard to whether LGBT books could be placed in the children's section. They wanted to place a book called My Princess Boy, in which it's a picture book which shows a father being proud of his son who wanted to wear a dress, and parents wanted to have that in the adult section of the library, not in the children's books. We know that Mouse, the Holocaust graphic novel by Art Spiegelman, was recently removed from the school library by a board in Tennessee, ostensibly because of vulgarity, because of his depiction of his mother, who was a Holocaust survivor, in the pages of the book. Nobel Prize winner Toni Morrison's books are often sought to be removed from school libraries, are often at the top of the list of challenged books. The Virginia governor was recently elected in part by exploiting a campaign ad that featured a mother who had unsuccessfully tried to remove her book Beloved from her son's high school library. The list of books that people would like to ban is growing. Activists today are sometimes consulting lists of books that have been found to be questionable by unknown folks, but then they compare them to the lists of books in the catalogs of school libraries, sometimes of public libraries. Now, the defense is one, and I think it's important for us to understand where a lot of people are coming from on this. Some people look at this not as banning books, saying we're not the government taking away the book from people. We're just saying our children shouldn't be exposed to this, at least with schools, or we don't want the public library to be promoting the speech, not that we think it should be banned, but that it shouldn't be in our library. One of the defenses is it's called parenting. It's not book banning. Be that as it may, the Washington Post recently reported on Saturday that schools nationwide are taking notice. They are quietly removing books from their stacks. The Washington Post talked about this librarian I have in this picture in the slide who came back from vacation and found a number of books had simply been removed without any consultation because the library authorities were afraid of being challenged. And it is not a fear that is unreasonable. In fact, legislators in some states are proposing bills that would limit what books could be accessed and some that actually penalize librarians. I know Ben's parents are here, but you don't have to fear for Ben because Ohio is not doing the unheard of that Idaho is, which is considering a bill to impose a $1,000 fine and 1 year imprisonment on librarians who lent material harmful to minors to anyone under 18. So this is something that is getting the attention. And even if there aren't actual penalties involved, librarians often fear the controversy that comes with it. As I was reading about the story from Texas, this became a controversy nationally, and their library had a great deal of attention called to it by the attempt to try to remove those books. Okay, so what people typically ask me is what about the First Amendment, though? The First Amendment is about having free access to information, freedom of speech, freedom of belief. And surprisingly, the First Amendment has little to say, certainly directly, about libraries, and there aren't a lot of Supreme Court cases on it. There are a few lower court cases, not Supreme Court cases, which ultimately interpret the meaning of the First Amendment, but those lower court cases have found that people have rights to access public libraries, but not necessarily to have access to particular books. When it comes to schools, the famous case of Tinker versus Des Moines School District. This is a picture of Mary Beth Tinker and her brother, who were suspended from their school during the Vietnam War for wearing a black armband to protest the Vietnam War. And the Supreme Court ruled that the school could not discipline her for her speech. And in that landmark decision said that students and teachers do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. So this case stands for the proposition that student speech cannot be banned without the school providing evidence that the ban is necessary to avoid material or substantial interference with schoolwork or discipline. Tinker has not been interpreted, though, as a positive right for students to access specific books or ideas. The First Amendment in the United States is interpreted as a protection against what the government can do, not what the government can be forced to do by individuals or forced to provide in terms of information. So that brings us to the one case that the Supreme Court has decided involving book removal. But before I get to that, this is called the Pico case. Before I get to that, I thought it would be helpful to just quickly sort of outline what might happen. I know Ben is going to talk about what happens in terms of the library when a book is challenged, but I'm going to talk about what the legal system would do if, say, the Bexley Public Schools or the Bexley Library removed a book because of disapproval of the book. What would happen? And just in very broad terms, you would need to have someone who has what's called standing to sue, someone who is actually injured by that, somebody who would have had access to that book that has it taken away from them, who then would need to obtain some sort of legal representation to file a suit, almost invariably in federal court. They're going to file suit in federal court because it's most likely that a federal judge would be immune to fears of angering the public, because the federal judge has appointment for life, and also because federal judges are quite conversant with enforcing constitutional rights. So what would happen is there would be a complaint filed in the district court here in Columbus, say, if this were to happen in Bexley. The judge would then render a decision on whether the book could be removed or not, or whether it could be enjoined, in which case they would order the library to return the book to the shelf or say, no, it's okay to keep it off the shelf. What happens then is there is an appeal in Ohio that would be to the United States Court of Appeals for the Sixth Circuit, which sits in Cincinnati, which would then review the district judge's findings. And then that potentially, if the Supreme Court of the United States agreed to hear the case, could then be appealed to the Supreme Court of the United States, which could ultimately resolve it. Now, most cases are resolved in the Sixth Circuit because the Supreme Court of the United States takes very few of them. So that's how it went. But there was a case, this Board of Education Island Trees Union Free School versus Pico, which went all the way through this process to the Supreme Court. And what had happened in that case was something similar to what we're seeing today. A number of school board members went to a conservative conference and got a list of books that the group considered offensive. And the board members came back from the conference and asked that those be removed from the library. They included a number of books, including Slaughterhouse-Five by Kurt Vonnegut, Black Boy by Richard Wright, The Fixer by Malamud. There was one called A Reader for Writers, which they never could quite get a reason down for why they banned it. At least one assertion was because it had Jonathan Swift's essay in it that promoted eating Irish children in a sarcastic way. And so they thought it was too, a modest solution was too brutal. But it turns out that it looked like it was because it praised a Black Panther as a role model. So there was some suggestion that the banning had to do with disapproval of the ideas. And in fact, in their press release, the board gave some credence to that by saying the books are anti-American, anti-Christian, they meant Semitic, but they said anti-Semitic, and just plain filthy. And they said it is our duty, our moral obligation to protect the children in our schools from this moral danger. So in that case, the students in the school district sued and said this violated their First Amendment rights. And the lower courts, I'm not going to go into them. There were so many opinions on this. There are actually too many opinions for me to simplify them. There were 4 different opinions from the trial judge, and then all 3 judges on the Circuit Court of Appeals had their own opinions as well, because nobody could quite agree as to how this should be analyzed. And so the United States Supreme Court took it up And, supposedly in the interest of clarifying things, really didn't clarify things. They basically ruled 5-4 that the board may have violated the First Amendment rights of the students, depending on the motivation of the board in removing the books. The court said that boards have significant discretion to determine the content of their school libraries. And that makes sense, right? I mean, we elect school boards to educate our children. We want them to make sound decisions, but they say that discretion cannot be exercised in a narrowly partisan or political manner. And they gave a couple examples in Justice Brennan's opinion. He said that if a Democratic school board said we're going to take out all books by Republican authors or promote Republican philosophies, or if a racially discriminatory board wanted to remove books written by or favoring equality for African Americans, he said that wouldn't be permissible. And so all of this depends on the motivation. And the test is whether the board intended by their removal to deny students access to ideas, and that this intent was the decisive factor. However, the court said if the removal decision was based solely on educational suitability of the books, the removal is perfectly permissible. You can see already that there's going to be some wiggle room here with those two concepts. In Pico, there was quite a bit of evidence that the board disagreed with the ideas in the books, as my summary already suggested. They talked about the books being blasphemies, offensive, anti-American, all buzzwords that to lawyers suggest there's hostility to the viewpoint expressed in it. But this raises the question of what happens if the motives are unclear? What if the board has multiple motives? What if one board member says, I hate the ideas, and another board member says this is educationally unsuitable? What do we do in a situation like this? What if their objection is to sexual content, as many of these challenges appear to be? They appear to be about as many First Amendment issues are about objections to sexual content. And so let me just give you one example. There are several from the lower courts. This is not a Supreme Court decision. This is a case out of Florida. And if any of you have been to Miami, Florida, there is a large Cuban American community there. They are very, very angry still at their treatment by the Cuban government, by Castro. And unfortunately for the library in Miami-Dade County, they purchased a series of books called A Visit to Blank, a visit to Finland, a visit to France. They also bought the book A Visit to Cuba. And a Cuban American parent read the book A Visit to Cuba. Now, it's a fairly innocuous picture book. It's a formula book. Children in Cuba do this. Here's what Cuba's history is like, and so on. People in Cuba eat, work, and go to school like you do. This was one of the sentences that outraged the parent in that city, and he requested that the book be removed because it was false. Because in fact, they said people do not go to school like you do because Cuba is a dictatorship, and therefore they don't have the freedom to do that. What happens is the library committee reviews the complaint, and the school library committees voted overwhelmingly to keep the books. They voted 8-1 and 15-1. They said the books were educationally appropriate, quite innocuous. They weren't particularly bothered by them, and they said, let's keep them. But the school board overruled. Now, the school board, I assume, I don't know this, but I assume it is elected. And so elected officials are much more sensitive to their constituencies. And the board had a number of comments that also suggested that they disagreed with the ideas in the book, saying they're extremely offensive, but they also said they were inaccurate and they were full of omissions. So initially, again, we had a trial court rule on it. The trial court concluded that the board was motivated by hostility to ideas. The judge said, hey, one board member said that this is hurtful and insulting to Cuban Americans. So we didn't, that suggests, again, hostility to ideas. The board also had said a number of other things. So the trial court concluded we can't ban books from shelves just because some members of the community find them offensive or disagreeable. That's what the court said in Pico. He attempted to apply that sort of motivation standard, yet the Court of Appeals reversed his decision. So they accepted the board's explanation. They said, well, in our view, when we read what the board members said, they said that this was really about accuracy and truth. And of course, it's a legitimate educational decision to make when someone is going to take a book out because it is inaccurate. They said the board did not simply dislike the ideas in the book. They said everyone agreed that the book contained factual inaccuracies, although there was a dissenter who said the inaccuracies they're seizing on are pretext. These are tiny, sort of omissions that you would find in every book. And the dissent said, if you took out every book that had a minor inaccuracy in it in the library, you won't have anything on the shelf, and Ben won't have anything to do here. So the bottom line is other courts have tried to apply this standard and have reached different outcomes. What seems to be key is the record of the motivation behind the removal. Harry Potter fared okay in Arkansas. So when a Christian group tried to remove the Harry Potter books from the school library because of its witchcraft and other sort of paganism, they were unsuccessful. On the other hand, voodoo and hoodoo was removed at the outcry of Christian parents in Louisiana, and the Fifth Circuit allowed that removal by saying that the board did not have a desire to suppress ideas. So the key is going to be, one, how much evidence there is of this sort of improper motivation, and how willing courts are to be delving into motivation. You can think about, questions of motivation are complicated because none of us can look into the minds and hearts of everyone else, and school boards have multifarious motives when they act. Libraries typically are not required to add books to the collection based on patrons' demands. The Supreme Court said this is not about adding books. This is about, once we've decided a book is appropriate, do we remove them? And so I think that removal is probably permitted as long as they are not motivated by hostility to the ideas in the books. And this is just, my own, sort of perspective from teaching con law for, since before Michelle was in law school. If this goes up to the Supreme Court, I would expect the boards to find sympathetic justices. Justice Clarence Thomas has tried to say that school children do not have any First Amendment rights. So he has been of the view that Tinker was wrong. And this is the most conservative court I have ever seen, although not quite as much on First Amendment issues. But the justices who were in dissent in Pico are much more akin to the justices who would be deciding it today. So that is my summary of the law, and I'll be happy to discuss more. Turn it over to Michelle.
Good evening, everyone. Thank you so much for having me. Hopefully we don't get feedback. Thank you to Ben and the Bexley Public Library for having us tonight. And thank you to Professor Kobil. I must say, full disclaimer, I did go to law school. I graduated from law school, but I am not a practicing attorney. And that's very, very important. But I did bring my con law book. I found it. And yes, it does have all of my notes from where I took the bar exam, and there's probably some things that would fall out, but yes, so, but it's an absolute pleasure to be with you here tonight and to share some information with you. I'm going to share a little bit of a different side of this. I'm going to talk a little bit about from the state and the national level as far as the advocacy side and what we're seeing in our public libraries. So we're going to start off a little bit, and I'm going to leave that up there for right now, but I do have a slide for you in a little bit, but I don't want to give it to you yet because it's going to be that good. So public libraries in general. So we are open to all. According to federal law, according to state law, according to everything that you've seen so far from Professor Kobil, we are open to all. We cannot and do not discriminate. And that's the starting point. You know, it's one of those things where I found myself over the years having to remind people of that. And so what does that really mean, open to all? That means that we serve everyone. Ben will know this, and his colleagues in the room will know this. Whenever we talk about it, we serve cradle to grave. And then sometimes we serve expectant mothers. So we serve kids before they're even born. When parents come in for story time, or when parents borrow books and are reading to them while the children are still in the womb. We're from cradle to grave. So, but that includes all ages, that includes all races, that includes all religions, that includes all genders. Individuals with disabilities, individuals that are in poverty, non-readers, as well as the LGBTQ plus community, and then some. I can't even give you the whole laundry list of people that we serve every day, and we do. And we do not discriminate. We do not stop them at the door, ask them questions, and then determine whether or not to allow them in or to allow them to borrow a book. That is not what we do. As you heard Professor Kobil talk about a little bit, there is the right to access information. We'll talk a little bit about that. You also there's the freedom of speech and also freedom to petition. And Ben's going to talk a little bit more about that and a little bit from the local side about what that is, a process in place for individuals who have concerns. And that's the freedom to petition government, because at the end of the day, public libraries are a form of government. We are. We're public institutions. But let's talk a little bit about what we do in that freedom to access. That's freedom to access information. I'm going to repeat that. Freedom to access information. You have a right and a choice to access information in your public library. Your public library has an obligation to make sure that information is available for you. So what does that mean? That means if they have a book on the shelf, I don't necessarily have to read it. I can if I want, but I'm not obligated to. If the library is having a program, that means I can go if I want to. It's a choice, but I'm not required to. That's a personal choice and a personal decision as a citizen that you have. And so I think many times I find myself, we have to remind people of that, especially in the context of this discussion. Because many times we may be in conversations at the State House or with legislators or with all sorts of different individuals. And they feel as though if it's a book is on the shelf or if the library is having a program, that individuals are required to participate or required to read. And that is not the case in public libraries. We offer diverse ideas, diverse information. Again, information and programs for everyone. What guides us in our work? Several different things. Obviously the law, but also as far as a profession, the American Library Association's Library Bill of Rights. You can Google it. I'm not going to go through it all, I promise. But you should look at it, and they update it regularly. But the Library Bill of Rights is important. The freedom to read statement, you do have a freedom to read. Again, no one is requiring you or obligating you to do that. In addition to that, we have a code of ethics that we follow. All of those things are very important. And I'm going to give you a couple of examples when we get into this, because when I have conversations with people and we talk about access to information or access to programs or materials, it's easier for us to put it in terms of specific examples. So Professor Kobil gave you some great examples about different books that had been challenged under the Pico case and had talked about freedom of speech and Tinker. A lot of times when I'm talking with someone, you may not realize that for some libraries, the two books that they have to order the most, and this came directly from one of my library directors, two books that they have to order the most that get checked out a lot or get stolen are the Bible and the Quran. And some people may be surprised, like, oh, that's available at the library? Why, yes, it is. Both of them are. And you can check them out. And as an individual, it is up to you to read. If you want to read that material, it's our job to make sure it's available. We don't endorse either one, but it's up to you as the citizen, as the library patron, as the library customer. If you want to read that information, it should be available to you. And this has come up before. We've talked about Dr. Seuss. Dr. Seuss was pretty popular, got a little bit of attention about it a year and a half ago. But when we start to talk about these things, people realize, oh, that's what that means, or that's what we're talking about here. Some of the books, and I'm going to give you a little bit of a poll here in a second at the national level, but some of the books that we have seen, at least here in Ohio, that have gotten questioned or petitioned for reconsideration, or a form has been submitted. It's not always the books that you would think of. One of the titles recently, and I don't have the exact title, but it literally was about the poop emoji. And someone had filed a form for it to be reconsidered. Most of the ones that we're seeing, or at least that we've seen over the past 6 months, are related to social emotional learning. Now you think about this. Where have we been for the past 2 years? We've been in a pandemic. Where have many of the kids been? They've been back and forth between in-person in school or doing virtual learning. Many people have had their lives turned upside down. And, you know, sometimes it's just doing everything they can day to day to try to have some kind of sense of normalcy. So social emotional learning is probably a really important topic right now. And there are some people who have serious concerns about having that type of a conversation or reading material that talks about social emotional learning. But I am going to give you some good news and some very relevant and timely news. Yep. So I was at a conference last week in Portland, Oregon, meeting with my colleagues from all across the United States, public libraries from all across the US. And our national organization, the American Library Association, had just conducted a poll, first of its kind, first time they've done it, to ask people, not just library supporters, not just Democrats, not just Republicans, but a widespread poll, how to gauge their feelings on book bans and the freedom to read. So this national poll was commissioned by ALA, and it confirms the national support for the freedom to read. 7 in 10 voters oppose efforts to remove or ban books in public libraries. 7 in 10 voters. Now we're going to break that down a little bit further because I do think this is important, because many times some people think that it's a partisan issue right off the top. Well, this poll, this survey, confirms that it's not. It's not a partisan issue. Like I said, remember I talked about the Bible, right? Talked about Dr. Seuss, talked about the Quran. This poll confirms across party lines that individuals in both parties are opposed to banning books. For those that were polled, that were Democrats, 75% oppose. For those that are independents or identify as independents, 58% oppose book bans in public libraries. And for Republicans, 70% of the Republicans that were polled oppose book bans in public libraries. So you're going to be hearing more about this sort of thing, hopefully in the coming weeks as we move forward. This poll was just released on Thursday, and today is Tuesday. So, but for us, this was affirming information, because a lot of times you never know what's out there, and to have a realistic poll, a credible poll, this was very important. So again, not a partisan issue, across party lines. It's that affirmation of what's important. So let's talk a little bit briefly about what's happening here in Ohio. We are not seeing the challenges that many other states are seeing. So our colleagues in Texas are having a very difficult time right now. Professor Kobil mentioned the situation in Tennessee with Mouse. Virginia's had some issues. Pennsylvania's had a few. Idaho's had some issues. In Ohio, we are not seeing that many of issues as our colleagues in other states. That said, mostly it is usually in school libraries. We have seen a little bit of an uptick in the past 6 months for public libraries, and there's a wide range. It could be someone just coming in and complaining, right, to the adult services librarian or the children's librarian or the reference librarian about a title that they see on the shelf or on a book display, or it could be about a program. That is very different from completing a reconsideration form, which Ben will talk about. At the state level, we have seen legislation introduced. One of those bills is House Bill 327. I'm not going to go into too much detail about it because we could be here for hours. But I will tell you that essentially it prohibits the teaching, offering, training of certain topics. And it's not just in K-12 schools where we're talking about, and I'm not going to call it divisive topics because the bill's been amended. We're on the -12 version at this point, and it's not even out of committee, which is not a bad thing. But it impacts and proposes to impact so much more than just K-12 schools. We're talking about colleges and universities. We're talking about state agencies. What does that mean? That means the Department of Commerce. That means the Department of Insurance. That means the Ohio Department of Health. Every state agency. It also includes political subdivisions. Well, what does that mean? That means your cities, that's your counties, county government, county commissioners, county agencies. That includes your townships. It includes your parks and recreation, all political subdivisions, including public libraries. In the state of Ohio, we are considered a political subdivision. So that includes us. So what does that mean? That means that there might be a controversial speaker or someone that's coming in, and if they're going to be talking about a specific topic, that could be prohibited under this bill. What does that mean as far as library materials? Does it mean that you're going to have to review the collection? Oh, wait a minute, there's a provision in the bill that requires that would require the library and other entities to review all of their materials to find out if they have any of these topics that are covered. We're talking about, in some cases, we're talking about millions of dollars that it would cost to have to review. I'm very curious, I'll have to ask Ben, I don't want to put him on the spot, but how many items they have in their collection. Because you think about that, every single one of those items would have to be reviewed. So this bill, we are opposed to it, obviously, and we've got lots of colleagues out there that are with us as a part of a coalition. But again, really, what does this mean at the end of the day? It means government would be deciding what you can and cannot have access to and what you can and cannot read, which is pretty scary, especially in the times that we're in right now and what's happening in the Ukraine. So you think about that. Government's going to tell you what you can and cannot have access to. That's not the government's decision. That's my decision. So something to think about. One other thing I do want to point out before I hand it over to Ben, Professor Kobil talked about Toni Morrison. Did you know that Toni Morrison is originally from Ohio? Yeah, she grew up in Lorain County, where she was also worked at the Lorain County Public Library. And the General Assembly, not too long ago, just within the past 2 years, passed and acknowledged and made Toni Morrison Day in the state of Ohio. So guess what? If Beloved is going to be challenged, what's going to happen? I mean, we have Toni Morrison Day in the state of Ohio. We acknowledge her, we recognize her, and we celebrate her and her work. So, you know, in many ways, we are not where some of the other states are as far as challenges, but it is something to definitely be aware of and to be ready for. And so that's all I have for right now. And I am going to now turn it over to Ben.
All right. Thank you, Michelle. Thank you, Professor Kobil. I never thought I would give a library program where I pull out a piece of our policy and go through it bit by bit. But alas, here we are. And however we want to do it with, if you want to pull the screen up and everything, that's fine. So I want to kind of just go through a little bit of what you could anticipate at pretty much any public library. I think you're going to have a material selection policy like this, and it's going to have 4 or 5 sections, and it'll kind of talk about what the aim of the library is when it comes to building collections. You're going to have a statement like this that says the Board of Trustees, administration, and staff are committed to these tenets, that a free and open access to information is necessary for citizens to think and make choices for themselves. That by providing access to a wide variety of facts, opinions, and ideas, the library helps to create a well-informed, enlightened populace. And it'll probably go on to say, we also support the American Library Association, freedom to read, as well as their Library Bill of Rights. Then there'll be a section that says library staff have a professional responsibility to be inclusive, not exclusive. So that's right here in our policy. In selecting materials for library collection and in providing access to materials, even if such standards offend the library staff or some members of the community. So like right away, right? And it says here that the responsibility for monitoring a child's reading, listening, and viewing rests with the child's parent or legal guardian. So we're very upfront about what the expectations are. Now there'll be a selection policy, and it's going to talk about how, because of the space in our building and our budget, what we can buy and what our limits are going to be self-imposed here. And it says that the inclusion of any material into the Bexley Public Library collection does not signify the endorsement of or approval of said material by library staff, administration, the Board of Trustees, either collectively or individually. So, right, I think anyone should come into a library and be offended by something that's in the library, because then that means we have a well-rounded collection. After that, you'll get into kind of the different things here that we take into consideration when trying to determine what to purchase a book by. And then it says we have a section here, an item will not be added to or barred from the collection solely because of an author's race, religion, creed, so forth. So it's very open. Then you'll have a gifts section. What do we do with gifts? This is policy again, I'm sorry. And then collection maintenance. And this is where we kind of get into when we go to remove things. What are we using to remove books from there? And then the last section is the request for reconsideration. And so this is what was referred to earlier. And there'll be a form like this that you'll be able to fill out and turn in with us. And then it says right here that we'll acknowledge that we received this and review it. We ask you a couple questions, the title, the author, what you found. Did you examine the entire resource, right? Did you read the whole thing? What brought this resource to your attention? What concerns about the resource that you have about it? And it says if you want, you can use other pages as necessary. I'm sure some might. And what are some additional resources you suggest we consult to provide additional information and or other viewpoints on this topic? So this is available. So there is a petition, what'd you call it? The right to petition. And I think that we have only ever had 2. One was a request for the sheet that never got turned in. And one was for, I think, a kid's book that we spoke to the person and they were like, oh, I totally get it. And it just went away. But the one that we got the request for the sheet for was a parody cookbook called 50 Shades of Chicken. And it was, the recipes were pretty distasteful. So I'll say that. And of course, it's a cookbook and a parody. So it apparently wasn't very funny. Now, in addition to that, you will probably, in most libraries, find a collection development statement. So this kind of gets more into the weeds. We've said this in the policy. What does it actually look like? When we say our local history collection, what entities are we talking about? And then when it talks about our, when we're going through the collection, deciding what to get rid of, it lists out with more clarity. If it's damaged, if it's outdated information. And so these are kind of the policies and the statements that kind of guide most libraries. You're going to find this in all libraries. I do think it's important to mention that in Ohio, our libraries are set up slightly differently. As Michelle mentioned, we're political subdivisions, and so that really gives us much more benefits, I think, than many other states. And I don't think people realize how it's set up differently, because in many other states, it's an extension of the city government. So if they have to reduce their budget on a city government level, the library can be on that conversation for the chopping block. And so we have our own setup for that. And it's why I think that the per capita of people that use their libraries in Ohio, in the whole United States, we have more people that use our public libraries here in the great state of Ohio. And so that's likely why we are so popular here. And we don't have that many books challenged here, at least in Bexley. And hopefully that continues to be the case. You know, for us, we think you can't determine if an idea is good or bad until you drag it out into the sunshine and take a look at it. And so that's what our job is professionally, right? You know, we understand that we've been given an important trust and responsibility from our community, and it's imperative that we honor that with openness, objectivity, transparency, and professionalism. So like we've laid it all right out here, how we do these things. And then if you engage with us, we'll work through that process. And so that's kind of what we have going on. And now I think we can go on stage and take any questions and have a little bit of a conversation. Do we have any questions from anybody?
Professor, in your presentation, you talked about the Idaho law that said that it was harmful to minors. How is this possibly proven? How can you prove that something is harmful to someone before they've even read the book?
Yeah, that's part of the vagueness sort of trap. I do think there's one hopeful sign. I did read that that at least one house in Idaho said, we're not going to move forward with this because essentially it's punishing librarians for stuff that's already on the shelf. So you can have the stuff on the shelf, but you can't lend it, and you're going to punish the librarian for it. It's ridiculous. It's terribly vague. There could be a number of constitutional challenges to a law like that. Absolutely.
And can I just make a little comment that I think what makes this so interesting for me personally, so maybe I'll take the director hat off, is that we are confronted with unsettling and upsetting images and content all the time through our phones and computers. So to come across an unsettling or unappetizing section in a book with the context and the perspective that you get 120 pages into that scene in the book that's unsettling, I think that prepares you to better understand and comprehend it. I think it helps to build empathy and understanding when you're reading books from a different perspective, that to pull it out of context and read it at a school board meeting or something can be very, well, that's terrible, but you don't have the whole context. And I think when you compare it to what's available on the internet, it's hard for me to understand, like, yeah, we should get that. If they're going to read 120 pages, like, I think that's a win from the get-go, but I'll put my director hat back on.
I will say that there was one point that I wanted to make that I sort of cut the last slide because I didn't want to go over, but I do think that the important thing for us to keep in mind is that it is ultimately our society's commitment to tolerance that is going to really make the difference here. I don't think we can rely on the courts to solve these problems for us, because one of the things that I found as I read this is that it's not just conservatives who are trying to remove books. I mean, right now that seems to be much more prevalent, but it's also folks on the left who don't approve of Huck Finn. One school board took To Kill a Mockingbird out of the required curriculum. You know, Toni Morrison has been banned from curricula by liberals because of its portrayals of African Americans. Maybe banned is not quite the word, but I think if we want to prevent this kind of stuff, we have to stand up for and defend the principle of tolerance. So I liked Ben's statement that he hopes to have something in the collection to offend everyone. So that is exactly what I hope our libraries do.
I'm not talking about an administrative function, you're talking about a legislative function. And traditionally, in my understanding, not being a First Amendment lawyer, is the problem with content legislation is either it's too vague, like the Idaho law, or it's too specific in which it chooses content that's acceptable, and that's not permissible under the First Amendment. I just wonder whether those might be grounds where we might have more hope for the courts overturning laws like the one that's pending in the state legislature here, or the Idaho law would get it in.
I do think you're absolutely right. I mean, as I said, there aren't a lot of cases, and almost all of the action seems to be in school libraries. I mean,
Yeah.
Michelle and Ben would know that. I mean, the ones I researched and came up with were things about, can a library ban some person because of their hygiene from going into the library, or, you know, things like that. I haven't seen much where city councils are trying to get people to take books off the shelves. Michelle?
Yes, when we discussed this getting ready for today, there is not a lot of case law. Like there's not, when it comes to public libraries, as far as banning the books. Not that we want to see any, because, right now, but I do think the legislation that is currently at the State House, that is House Bill 327, it didn't originate in Ohio. Like other states are seeing that type of legislation being proposed verbatim. They just stick a different number on it and stick a different state name at the top. So it's not something new here, or didn't originate in Ohio. So, but we'll see how things go. Hopefully there's no test case out there. We want to continue to do what we're doing. But there's just not a lot of case law out there right now on public libraries.
I think you are right, though. I think there's a really good distinction to be made between school and public libraries, in the sense that schools have more of an inculcation function that is not present in a public library. So therefore, I think there's a really good argument to be made that our First Amendment protection should be more vigorous in the context of a public library. I would rule that way if I were on the court, but yes, there just aren't the judicial opinions on that, but that's a good point.
Well, so I'll back up a little bit. Well, the poll that the American Library Association did was a national poll. So it was not just Ohio. We're talking about people from, they had hired, it was a national poll, and national consultants who do polling. They wanted to make sure it was a good and diverse representation. So, because we all know there's polls out there that you can do where you get the answer you're looking for. But this poll was not done that way. So the 71% of voters, that's that's a national poll. The two individuals that are the primary sponsors of House Bill 327 one is from Geauga County and the other one is from Ashtabula County. So they're from Northeast Ohio. But again, the bill as it was originally introduced and the original concept of it, there's mirroring legislation that's been introduced in other states that's literally word for word the same. It just happens to be in a different state. So
I think if I'm not, Michelle, might be being more cautious than I have a need to be, but I mean, I think this is part of the anti-critical race theory bills that have been running through the legislatures that have been, promoted under the parents' rights, sort of aegis.
So on 327, what do you think are the odds of its passage? Or how much is political posturing? Yes, I'm putting you on the spot.
he's family, right?
Yeah. I'll talk with him later.
Don't worry, he's coming.
I can't specifically say where the legislation came from. We do know that, obviously, Representative Sarah Fowler introduced it. She's one of the sponsors, along with Representative Grindell. And so it is currently in the State and Local Government Committee. It has not had a hearing for a couple of weeks, which is a good thing. We have been very vocal. Our partnership and our coalition of other local government groups have been very vocal. And so there were the sponsor made some comments last week to certain members of the media. It did not come across very well. Speaker Cupp came out and made some comments following her comments. And so, I think at this point, legislators are hearing from their constituents, from their multiple constituencies. They're talking about what this bill would really entail, what it would mean. And so, like I said, right now it's at the very early stages of the legislative process. Our goal is for it not to come out of committee, but that's kind of where it is right now.
We have a question from the online chat. Someone asked, what can library staff, library patrons, and citizens do to support freedom of information in their libraries and schools if an item is challenged or banned?
You want to start with that one?
I think so. Our policy says that anytime we get a request for reconsideration, obviously we would look at it, study it, give some information for why we selected this book. It's a highly recommended New York Times best-selling book. And I think that might be an important thing to mention is that, we're buying books from publishers. So the free market does have a play here in what publishers are choosing to print. And so, so then we kind of give that, and it also goes to our library board. And so then that would go under that consideration, and then we would follow up. So certainly if someone had challenged a book and you felt as though that you wanted to challenge the challenge, I think, communicating with your library board, that would be how you would say, no, we think this is important to have in the library and here's why. And so, we want to be representative of the community we serve. I think most libraries do. And so any and all feedback and input that we get, I think we take very seriously here and make sure that we share that.
And Ben's comment about the publishers is very important, because when we had, and I'm sorry, I'm still kind of in the pandemic fog. I think it was in the spring of 2021, or maybe in 2021. The issues came up around some of the Dr. Seuss books. And it was not the facts, which sometimes get lost, right, in all of this. It was a decision by the publisher in that case. And so, but it came across as, well, does the library have this book on the shelves, or are you removing it? And it wasn't that. Some may still have had them in their collection, but it was a decision of the publisher at that time. And so, in all of this, because it is a business. I mean, yes, we tried to provide as much access as we can, but at the end of the day, even if something was banned from a library, that doesn't mean that it comes off Amazon and that it can't be purchased on Amazon, or that you can't go to Walmart or Target or the Book Loft, little plug.
Or Gramercy across
Or
the street.
sorry, yeah, sorry. So,
And sometimes if it's banned, it shoots up in
yes,
sales.
it does. Yes, it does. And so, which I think is interesting though, because if you talk with some authors, because their goal for authors, they want to be on the New York Times bestseller list. As soon as their new title comes out, they want to be in the top 10. That's their goal. That's what publishers promise them when they do these, when they do the negotiations. But for some of the authors, and I'm not going to quote him exactly because I can't remember, but Jason Reynolds he gets this question all the time, because he's had several books that have been questioned. Yes, sales may go up, but the concern is if something is removed from the shelf, that means someone's not going to have access to it. And in some of these cases, these are kids, they may not be able to go on Amazon, or their parent, or, may not be able to go purchase the book. That's the whole point of the public library, is so that everyone has access to information. And so, for some of the authors, they are very concerned about it. I mean, yes, their book sales may go up, but at the end of the day, that means someone is being denied access to their material.
I mean, the other thing that I would add, just because I'm a veteran protester, is organize a protest. That's what I would do, is protest removal of that book. So if, the school tries to take away Harry Potter, get the kids out there, demonstrating and getting their voices heard. Because from what I could tell reading these cases, a lot of the school boards were responding to local political pressure. So to the extent that you can raise your voices up and not just be sanguine in thinking, oh, they'll never take those books away, it can happen anywhere. And so I think that's what we can do.
And I will share one more story just because it's hilarious, but I can't say who the legislator was, but he had 3 daughters, or has 3 daughters. We did a special story time with him. And one of the stories that he shared at the time was that he was just appalled at the fact that people had issues with Captain Underpants. And like how, these are books that he reads with his daughters every single night when he comes back home after being here in Columbus. And he said, you know what, Michelle, the first thing I did, I went out and bought every single copy of Captain Underpants that I could possibly find. And he just really wanted to stick it to, like, he was just appalled. Captain Underpants. What is wrong with Captain Underpants? So, but it just shows you how crazy it is sometimes.
We have another question from the chat. If someone successfully petitioned for a book to be removed from the library, would that prevent the library from having public programs discussing the book? For example, could the library not host a program titled 50 Shades of Chicken? Why it was removed from our collection?
That is a wonderful question that I offer up. No takers. I think that this would be kind of direction of the board again, right? The conversation with board members about whether 50 Shades of Chicken is appropriate to talk about. And I again, go back to the question that was asked right before this. If we heard from the community, we would respond in kind. And again, the best way to know that 50 Shades of Chicken is a bad idea is to air it out in public and talk about it to know whether it's a good or bad idea. So whether, we've had some controversial programs here that some people might find controversial. We're in a really great, tolerant community that wants to have good conversations. And so we're able to offer and host these programs. So that may make us a little different than some other libraries who are maybe tuning in and watching. But that would be, I would want to have a program about something about chicken.
The cases, at least with the school libraries, actually distinguish between something like that. They'd say, well, the school is taking the book out of the library, but they're not banning people from talking about the ideas in them. So you may have a little stronger First Amendment argument that, I have nothing to say about what the library powers that be would do to Ben if he had said, well, I'm going to have this program, even if you make me take the book away. But yeah, in terms of your constitutional basis, it would be even stronger because that's a discussion, that's not requiring the government to keep materials or on the shelf, which they have a greater latitude to remove.
Any other? No. Okay. So I just want to say, years ago, when I was working the desk, I had a beautiful interaction that I think kind of sums up what we're talking about. We had a older gentleman come in and he's like, I want to see some books on climate change. So I took him over to our climate change section, and I realized that maybe we needed to update some of our climate change books. And he took a stack of books, and as he was walking by the desk to go check them out, he goes, I'm going to figure out for myself whether I think this is real. And that exactly is like what libraries should be about, is that you can come skeptical, believing, and get books and read about it. And so I do want to close really quickly. We have a thing with Ben Franklin here in our community. And 300 years ago this year, I want to quote a letter that was published in a newspaper by a 16-year-old Benjamin Franklin. Without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, which is the right of every man as far as it does not hurt or control the right of another. Whoever would overthrow the liberty of a nation must begin by subduing the freeness of speech. So thank you for tuning in to tonight. Thank you for our presenters to share with us so that we don't subdue the freeness of speech here in 2022. So thank you all for tuning in. Thank you for coming, checking out our program guide for other programs, and have a great night.
Thanks, Ben.